Well, welcome everyone. I'm glad you're really here to join us on this call tonight for our webinar on the ERA and the status of the ERA. We have two really amazing speakers tonight. We have Jessica Neuwirth. Jessica is the president of the ERA Coalition, and also Bettina Hager, and Bettina is the director in D.C. for the ERA Coalition and the Fund for Women's Equality. I'm not going to do a long introduction because I want to give both Jessica and Bettina as much time as possible on the call, and then I'll ask that we can let you know, or you can, we'll see how the call goes, probably about, well, it's 4:32 now. It's 4:32 here in Arizona. I apologize. It's 7:32 back in on the East Coast. And if we can say about 8:15 at least, if we don't happen to stop before that, to open it up to questions, is that okay with both of you?
Yeah, and I also suggest too that if you're on the computer, there is a chat box. So if you want to type any questions out that I can probably read through when we have the question and answer period to make it go smoothly, you can do that too.
That would be great. Is that okay with both Jessica and Bettina? We do it that way?
Sure.
Yeah,
absolutely.
Okay. So I'll let both of you decide, who's going to start and who's going to speak when. And I'm going to go on speaker because I have a student with me, so I'm excited. All right.
Great.
Thank you so much.
Yeah. Well, I think Jessica was hoping that I would go first, so I'll just do some introductions, and I think what I would like to cover is kind of where we are currently legislatively, and then maybe tying into some of the current events that have created a lot of energy around the Equal Rights Amendment, and then have Jessica cover kind of a more new initiative that we're working on, which is some expanded language that might be really interesting to everyone on the phone. So kind of where are we now today with the Equal Rights Amendment? There have been, historically two sets of bills introduced into the House and Senate federally. One is called the three-state strategy, and one is the traditional strategy, which follows the Article 5 constitutional process, which is where you get 2/3 of the House and 2/3 of the Senate, and then 3/4 of the states. And I think because of the incredible energy around the Women's March, they've already been introduced, which is actually unusual for what I've seen. Generally, the bills are introduced earliest March, but post this election and kind of all of the rhetoric around women's issues really, put a fire in everyone's belly to prioritize introducing these bills and these issues. So the bills were introduced in January the first introduction was prior to the Women's March. And all of the bills have pretty strong co-sponsorship. There's about the three-state strategy. The Senate bill is SJ-Res 5, which was introduced by Ben Cardin, and that has 28 co-sponsors. And then HJ-Res 53 was introduced by Jackie Spear, which has 144 co-sponsors. So those are pretty strong introductions, especially for having been introduced in January, which is the first month of the congressional session. For the traditional strategy, Carolyn Maloney introduced her bill, and she has 98 co-sponsors, and she has bipartisan support. So she has 5 Republicans on her bill. And that bill is exciting because it adds a new sentence to the traditional language that you find in the 1972 bill, which is what is being worked on in the three-state strategy. It specifically mentions women and gives affirmative rights. And then Senator Menendez has introduced the traditional strategy, which is the identical language to the 1972 language, and has 11 co-sponsors. So I think that what's exciting about having these early introductions is that means that our activists and the grassroots can get working right away to increase the number of co-sponsors on the bills, which shows Congress how important it is to then pass it through the judiciary, get hearings, and then hopefully eventually a vote. And I think one of the most exciting things that we're seeing right now is that there's very kind of unexpected, at least in my opinion, movement in the states. So I don't know, has everyone been following what's going on in Nevada? I don't know if anyone has been following. So in Nevada, Nevada was one of the states that never ratified the Equal Rights Amendment, the 15 states that never ratified in the 70s and 80s. And during the last election cycle, they had kind of a switch in power in their state house and state senate, so that both of their state senate and their state house are majority Democrats, which, you know, the Equal Rights Amendment isn't a partisan bill, and we don't want it to be partisan, but historically, and even if you look in Congress, it is largely supported by Democrats. And well, historically, recently, it was introduced by Republicans in the 20s, but recently it's been introduced by the Democrats. But with that kind of change in power, there was time and energy to put forward a resolution to ratify the 1972 language of the Equal Rights Amendment, which was never ratified in the 70s and the 80s. And there had already been kind of grassroots organizing, which is why it's so important. You know, one of the questions that I saw in this webinar is how do we do this? And I think one of the things that Nevada shows us, and that, you know, the coalition has been working on, is setting up, you know, the plan so that if it is the time for movement, that there are people who are able to move it successfully. And in Nevada, they had been working on the Equal Rights Amendment for a couple of years, but the legislative makeup just wasn't really conducive to its passage. And so with this election and the new legislative, you know, makeup, they move forward and have already, and it looks like they will be ratifying the 1972 language. And it's passed through the Senate, and then it's now passed through the Assembly Committee that's in charge of sending it to the floor of the full Assembly to vote. And that vote is going to be next Monday. And then it goes back to the Senate for just a technical amendment and will likely be ratified on the 22nd, which is a symbolic date because that's when, March 22nd is when it was, the Equal Rights Amendment 1972 was passed to the House and Senate. So I think that what this shows us is that it's kind of a new atmosphere that where people are paying attention to these issues, and where we can make strides, and where there is movement, and there are people who want to take that initiative. And so I think, you know, where is the Equal Rights Amendment today? In some ways, you know, the results of the last election cycle may seem to have been a step back for women's rights, but in reality, they've created a lot of energy around these issues because they have brought it to light. Because a lot of us have been working on women's issues. We know that we need to pass an Equal Rights Amendment. We know that these are issues. But through the rhetoric, everyone now kind of, it's hard to ignore the fact that there is a lot of sexism and inequality that exists in our country today. And so it's become much more part of the national dialogue, which is really important to getting the ERA passed. And with that, I think the other thing that we've been working on is kind of an idea of an expanded language, also coming out of this election cycle, which I am hoping Jessica can introduce.
Sure. Thanks for doing that intro. You know, I actually realize I'm not that clear on like how much people on the call know about the ERA. So there may be some more background that would be useful. But I think when we started our campaign a few years ago, one of the things that we noticed and that we further documented with polling, which had already been documented by polling, is that most people, 80% of the population, thinks that we already have this right in the Constitution. So that's one interesting fact that I think is our biggest challenge in a way, is how do we get people to even know what the ERA is? Because In 1972, it was passed, and there was a lot of energy for 10 years till 1982. And then after the deadline expired, it kind of went off the radar screen. It was alive in Congress through bills continuing ever since then, but it didn't have a lot of public visibility. So there's a whole generation of people that literally have no idea what it is. And just to kind of assume that we have constitutional equality for women, which we absolutely don't. So that's one challenge. And then the other thing I learned in talking to people is there wasn't a really clear sense of even why we need the ERA. There was just some sort of vague sense of like, don't we already have it? And, you know, what's the 14th Amendment about? And so just by way of background, I mean, there are some problems with the 14th Amendment, which is equal protection of the law. It doesn't specifically mention anything about sex discrimination, but some people associate it with that. Although I like to remind people that the 14th Amendment was passed in the mid-19th century, and it took more than 50 years after that and a whole other constitutional amendment for women to get the right to vote. So the 14th Amendment couldn't even give women the right to vote, and there were lots of other cases under the 14th Amendment where women tried to get various rights and couldn't get them. It was only in the 1970s for the very first time that the 14th Amendment was used to start to dismantle some of the discriminatory laws. And I have to say, in fairness, a lot of those laws are gone now through litigation and law reform. So then why do we need the sex equality provision of the ERA? Well, the answer basically is there is no constitutional framework or basis for a lot of the protections that we need. And three areas that we've particularly focused on are discrimination in pay inequity, and pregnancy discrimination, and violence against women. Those are just three of many areas where there are lots of ways in which the current legislation that we have, like the Equal Pay Act, it doesn't work. And we all know that women don't make a dollar for every dollar a man makes, and that it's, you know, women of color make much less than white women proportionately, and there's just all kinds of discrimination built into our system that's very hard to address. And some of the problems with the 14th Amendment include what's called the state action requirement. So for the 14th Amendment to be relevant, there has to be some act by the state. And a lot of employment discrimination and other forms of discrimination that are really, really problematic for people in life are not state action. They're private action in the private sector by companies. So they wouldn't fall under the scope of the 14th Amendment. And then there's another piece of it, which is the intent to discriminate. You have to really prove that someone intended to discriminate. And that became an issue, for example, in the Walmart case, you know, where you could just see that even though there were just mountains of evidence statistically that women were paid less and promoted more slowly, the Supreme Court held that was nothing. That wasn't even the tip of the iceberg of what you needed to prove a violation, that you almost needed like a smoking gun memo saying pay women less, because otherwise you couldn't prove that state of mind that was needed under the 14th Amendment. So a lot of those issues are also true for race discrimination, even though the 14th Amendment is thought of as being passed to address race discrimination. It has those limitations. And like sex, race was clearly left out of the Constitution when it was drafted very, very intentionally with slavery, you know, and women being disenfranchised. So what we were thinking over time, but in particular after the last election and the kind of lead role that the women's movement has started to play in the whole social justice movement with the Women's March, which was very, very broad in its scope of issues and really, I think, had an agenda that went to a lot of human rights, fundamental human rights issues. If we're going to go to all the effort of doing a whole new constitutional amendment, you know, why just limit it to sex discrimination? Why not all forms of discrimination that we would want to cover, which is actually how most other countries in the world do that. If you look at the equality provisions, and I should say that most countries in the world that have a constitution have a non-discrimination provision, and all of them prohibit discrimination on the basis of sex and race, or pretty much all of them, as well as other categories of discrimination like disability or national origin. So we, after the election, got a team of lawyers together and really spent quite a lot of time to look at what would an equal rights amendment look like for the U.S. Constitution if we tried to include everyone and really break down all the different forms of sex discrimination, including sexual orientation and pregnancy discrimination. And in the area of race discrimination, things like national origin, ethnicity, and color, and other categories of discrimination like disability or faith-based discrimination. So we've come up with a very expanded version of the ERA that we've been talking to various policymakers about, and it hasn't been introduced at this point. And we're still looking at broadening the constituency and really reaching out to civil rights groups and LGBT groups to talk about whether that is something that they would like to try to join forces on. And meanwhile, as Bettina said, the other bills are pending in Congress and hopefully moving forward. But nothing that we're talking about with an expanded ERA really relates to the kind of thing in Nevada, because anybody who is approaching this from the point of view of the three-state approach, where you're just going to remove the deadline and try to get 3 more ratifications, if that works, you're just kind of stuck with but the original language of 1972 is the amendment that was passed at that time. You can't change that, unless you start all over again. So the theory is, well, the three-state amendment process, the three-state process that we're looking at may or may not work legally because it has some challenges. So if it doesn't work, and if we're going to start all over, do we really want to start all over with that same language, or should we broaden the base of language if we're going to go through this process and really try to make sure that everyone has equal rights in this country? So that's a long, roundabout way of getting to this new expanded version, and I think maybe I should just stop there and see if there's anything else Bettina wants to add, or if you want to open it to questions.
Well, yeah. I mean, I think that what you said, and I'm sorry I didn't provide. I've provide more background on the history of the Equal Rights Amendment. I'd spoken to the EPW earlier, so I was just assuming that sort of broad-based. But thanks so much for giving more information on the history, Jessica. But yeah, I think that one of the things that is important to the conversation of possibly having a new kind of more inclusive language is that moving forward, the goal is to get broader constitutional equality no matter how it comes about, whether it be through a more inclusive amendment, the three-stage strategy, or the traditional kind of strategy that focuses on sex discrimination, that the goal in the end is to broaden is to get stronger protection for all kinds of discrimination in the Constitution. So I hope that that's not too confusing, but I think because of this new idea being brought forward, I think that the question and answer period would be really important to have. So I agree about opening up to questions.
Tina and Jessica, this is Carol, because I just do want to clarify some things before we get into too many questions. Is the traditional, what you're calling traditional, would that be the start over? They were calling it the start over at one point?
Yes.
All right, good.
Well, let me just clarify. There's the start over approach means that you have to start again with Congress, get 2/3 of each house, and then 3/4 of the states. So what that has meant traditionally is the 1972 language, and I think some people have called that the traditional approach. But as Bettina mentioned, in the last session of Congress, Carolyn Maloney actually changed that language and added one sentence at the beginning that specifically has the word women in it. So it's a little bit confusing, but there are 2 versions of the start over traditional approach. And I don't know if it's appropriate to call Carolyn Maloney's approach the traditional approach because she added the new sentence. And then, of course, this new expanded ERA would also be a start over, but obviously not the traditional approach. So maybe what you mean by traditional approach is the 1972 language, sort of starting all over again. But it's sort of morphed into a couple of other possibilities with the new language that Carolyn has and the new language that we have been talking about in a more expanded way.
It is a little confusing because the three-state strategy would seem to be the traditional, but it's not, according to what we're talking about.
I think it's not called, I don't know about the terminology, but I think the reason it's not traditional is it actually is only a pretty recently, I think it's about 10 years old, that strategy. The deadline expired in 1982, and what happened was in the 1990s, there was another amendment called the Madison Amendment that was actually drafted by James Madison in the early days of the Republic of the country. And the Madison Amendment was a very sort of old, arcane amendment, and it had been sitting around for 200 years, and I think there had been some technicality that had prevented it from being ratified in one state or something like that. And so that was corrected in the 1990s, I don't know, through some type of a administrative action that someone realized, and the thing went through, and then people started to wonder, well, the Madison Amendment took 200 years to ratify, so maybe we can just take more than 7 or 9 or 10 years for the ERA to ratify. And that was a new idea that people thought of because they saw the Madison Amendment. And the Madison Amendment really just has to do with the payment of congressional members of Congress, pay raises. And it was never challenged in court. And unlike the ERA, it never had a deadline. It was passed, no constitutional amendment ever had a deadline until Prohibition in the 19th century. And at that point, they put in the 7-year deadline. It was the first time there was ever a deadline in an amendment. And the reason for it, what we're told, is that the politicians wanted to support the temperance movement, but they really didn't want to prohibit alcohol. So they just put a deadline thinking, well, it'll never get ratified in 7 years, and then it will look like we support it, but we won't really have to stop drinking. And then after 18 months, actually, it was ratified. So it's kind of ironic because that's the only amendment in the Constitution that was ever rescinded by another constitutional amendment or a constitutional convention that took away Prohibition. But the one thing that remained was that 7-year deadline, and in virtually every amendment since then, there's been a 7-year deadline. So the status of that deadline is not required by the constitutional amendment process, but if you have it in the constitutional amendment, the question is, can you change it later after it's expired? Is it a 2/3 vote? Is it a 3/4 vote? A 2/3 vote or a majority vote? There are a lot of legal questions that are unanswered because that Madison Amendment was never really challenged in court, and it didn't have any deadline to begin with. So that whole deadline question is a legal question. And I think people see, well, maybe it could be a shortcut. So it could be a shortcut if the courts would approve doing all of that, but it's an untested legal question, so it could also not be a shortcut.
And when I say traditional, what I mean more is the actual strategy of doing a constitutional amendment, because going forward with the 2/3, 2/3, 3/4 is the traditional strategy of getting a constitutional amendment. So some people don't like the term start over because it seems to have kind of like a negative connotation to it. So there are people who use traditional strategy as in saying the traditional strategy towards getting an amendment, because as Jessica said, the removal of the 3-state deadline isn't the traditional strategy for getting an amendment passed. It's not the traditional process.
Okay. And just, yeah. I'm just on clarification, and we can go into questions. So if we can go back, you said it kind of quickly for us. What is the House bill and what is the Senate bill numbers?
So the House bill, to go by strategy, because sometimes I think that's easier. So when you're talking about the 3-state strategy bills, the 3-state strategy bill in the Senate is SJ Res 5, and that was introduced by Senator Cardin. And in the House, it's HJ Res 53, which was introduced by Jackie Spear. And if you're going for the traditional start-over strategy, that's SJ Res 6, which is Senator Menendez, and HJ Res 33, which is Congresswoman Maloney.
Great. Thank you. And then one more clarification. So did Nevada ratify the ERA?
They're on their way.
They're on their way. Okay. What's missing?
So basically, it's the state legislative process of ratification. And so their process is they have the bill. It's actually the Senate bill, and they have to pass it through the Senate. Similar to the federal process, they have to first pass it out of committee. And so they passed it out of the Senate committee, and then the full Senate voted. And the full Senate voted, and then the actual Senate bill goes to the Assembly, and they have to pass it out of the Assembly, which they just did 2 days ago, and then they have to vote on it in the Assembly, which is what's scheduled to happen on the 20th. And then after that, it just goes for a technical amendment on the 22nd, and then technically would be ratified and sent to the archivist at the Library of Congress, and then it's up to the future to tell us what happens from there with it.
Okay. So with the 3 states that we said we still needed, if that was to go through, Nevada would be one of those 3 states?
Exactly.
Okay.
Yeah, I think what's really important about Nevada, the bills that Bettina mentioned in Congress, the Senate and the House bill, on the 3-state side, what they say is that we should remove the deadline. So those bills have been there for a number of years now, but they haven't passed. So there's been no congressional act to remove the deadline. No state before the deadline has ratified. So this would be the first time that there was really any kind of serious legislative action on the ERA, and it would be, I think it would be, a real dramatic moment coming next week to just say, well, now Nevada ratified the ERA, so they become the 36th state, and we need 38 states, and I think it will be a really great opportunity to just raise the profile of the ERA so at least people know what it is. And then, there may be some legal questions about the status of it, but I think it will move the discussion forward. And it may also help move the federal legislation forward, too, because if you are trying to move the 3-state strategy, it's very helpful to have a congressional legislation that takes away the deadline. You can see, that would be very helpful, because otherwise you have this deadline and then you ratify after the deadline. If Congress says, you know what, we're going to just remove the deadline, it really helps the legal argument for the 3-state strategy.
That makes sense. Now, are there any other states that are close that we know about that we can push, or anybody?
Well, there are states that have movement. I mean, I know. So I think that the Nevada really kind of is a game changer, because there are states that have had movement. Illinois was quite close, like maybe 3 or 4 years ago. Right. Virginia, they introduce every year, and it always gets passed by the Senate and stuck in their assembly. But I think that even with kind of the success, or the almost success in Illinois, to have a state ratify is more, it is kind of inspiring for other states who are looking at it, who maybe people thought, even if they thought, I really want this to happen, they didn't necessarily see it coming anytime soon. Mm-hmm. So I think that there are states that it's been kind of bubbling up in, but if Nevada ratifies, then who knows? I mean, I've seen on social media people calling, does this mean that Illinois is next? And a lot of Illinois grassroots people are saying, yeah, we're next. So it'll be interesting to see how that energy gets kind of transferred to these other states where there have been activists and they've been working, but it hasn't necessarily been ratified in their states.
Yeah, that would be great, because I think that gives them the motivation. I was asking because as one of the organizations that's a sponsor, if we knew there was a state that we could really, get on board with and try to make it happen. We get 2 more mm-hmm. states, like you said, that certainly pushes Congress to do something, I would think.
Mm-hmm. I had a question. This is Pat from North Carolina. There's a group of us down here who have affiliated with the ERA coalition at the national level, mm-hmm. and we're working on that. In fact, we have a House bill and a Senate bill that have been dropped. They're in the Rules Committee at this point, and we were down there on Tuesday lobbying. But the question I have is, once we get the additional 3 states, what happens about the states who have chosen to try to rescind their vote?
Well, so I think what would happen, the way our system works, people do legal challenges. And so what would likely happen is if the 3 states were all ratified, and I guess it could happen even before then, anyone in another, and someone decided in Congress to accept those ratifications and to declare this Constitution amended, so you'd need that move. And then if there was a state that had rescinded that said, wait a minute, no, we can't be counted because we rescinded, they would bring a case. And then it would go into the court system, and then the courts would have to decide, can you rescind your ratification? Because that is not really a legal question that's ever been decided. What happened was those states rescinded. The deadline, which was originally 7 years, was expanded to 10 years in the late 70s. And there was a state, I think it was Idaho, joined by maybe Washington State. There was 2 states that brought a lawsuit. And it was brought in the courts, the federal courts in Idaho, and there was a district judge who did a judgment. And he said, you know what, you can rescind. So the 5 states that rescinded are allowed to rescind. And you know what, you can't change the deadline once you have the deadline. So that would have really killed all of this. But it was appealed. The decision was appealed up to the Supreme Court. And by the time it got to the Supreme Court and they were ready to hear the case, 1982 had come and gone. So the deadline had already expired, and the case was considered moot. It was thrown out, and that lower court decision was vacated, which means it has no legal effect. So we really don't have to look at that decision as a binding precedent. It gives you some insight into what one judge in Idaho thought, 20, 30 years ago, but we really don't know what a federal court would say today, but those would be the arguments then, and that's how it would happen. Someone would go into court who doesn't like the ERA, either, I guess, probably a state that rescinded, and then it would be a judicial decision that could go up to the Supreme Court for a final decision.
Okay, thank you.
Okay, I have a couple questions that have come my way here. This is Sue. One question is, what is the process to eliminate the deadline for the ERA and any other one? And the other question is please confirm, does any future constitutional amendment automatically have a 7-year limit?
Let me start with the second one. No. And of course, any new ERA that we would do, we would absolutely not want to have any deadline, because I totally believe that if we had not had any deadline, we would have had the ERA a long time ago in the Constitution. What happened was after the deadline, people stopped working on it because they just weren't thinking about it in terms of this new approach. So that last question is easy. The deadline comes when Congress passes the amendment, and in some cases the deadline has been, like in the case of the ERA, in the preamble, which is one of the legal arguments people make, that because it's not in the text of the amendment, then it's not really part of the amendment. So it's easier to change it or not to even take it into account at all, because it's not in the text of the amendment, it's in the preamble. So it's up to Congress to either put a deadline in or not, and where they put it and how strong that would make it. So that's the second question. And then the first question was how do you remove the deadline? I think that's where there are these 2 bills in Congress, and if they pass, I think, that's their hope, is that would be seen as removing the deadline. And again, that could be challenged by someone who doesn't want to see the deadline removed, and it would probably go up to the Supreme Court, because it's a question about our Constitution that's never really come up. There are some cases that are somewhat relevant, and they say things like, well, even though the Constitution doesn't require you to have a deadline for amendments, you're allowed to have a deadline. But it doesn't tell you in that case, because it wasn't an issue in that case, whether you have a deadline, it can be extended or not. Or if you have a deadline and it expires, it can be removed or not. Those are just completely open questions that we don't know what the Supreme Court answer would be.
Anybody else have any questions?
Well,
Well, I wanted to say, sorry, to go back to Pat's comment about North Carolina, I wanted to say that the first mentioned North Carolina and saying that they are doing really amazing work. But another thing that they're doing there, which I think is really helpful, that we can do in a grassroots level, is they're passing a lot of local local resolutions. I don't know, Pat, if you want to speak to that, but I think that that's a really great way to be prepared for when it is, a Nevada moment, when it is time to move, or when the environment is right for the Equal Rights Amendment. And I think that these sort of kind of grassroots activities help every strategy that we're working on, because all of the strategies that we're working on eventually do go back to the states, and they go back to grassroots movement. So I just wanted to point out the great work that is going on in North Carolina at the local and also the state level.
And let me just jump on that and also just do a quick ad for another upcoming event, since there are people from across the country here, because what I was saying before, and I think is related to these grassroots activities, is there's a real lot of ignorance about the ERA. People don't even know what it is. People don't know why we need it. And so some of you may have seen this film, Equal Means Equal, which is really compelling documentary that covers lots of different areas relating to the status of women in our country and why we need the ERA, and how not having the ERA has really hurt a lot of women who have tried to get justice for various forms of discrimination. And that film has been shown here and there and all around. It's something we've encouraged groups to do as a way of just kind of educating people, raising the discussion, getting people mobilized to write letters to members of Congress or go see their members of Congress, or do something in a local or national, state level legislature. And so I've been working with a group of students at Hunter College here in New York, and they are organizing a cross-country campus day for the Equal Rights Amendment on April 21st. And what they're doing is asking all of these campuses across the country to do a screening on campus, and afterwards they're going to live stream a panel to talk about the ERA, and on the panel will be Gloria Steinem and Patricia Arquette, who's been a really ardent advocate for the ERA, and one of the really important plaintiffs who's in the film, Betty Dukes, who was the plaintiff one of the key lead plaintiffs in the Walmart case, will be on the panel, and Carolyn Maloney, one of the proponents in Congress of the ERA. And there'll be a chance in all of these campuses for people to do Q&A through Twitter and some form of social media, with the panel back and forth. And we just think it'll be a great opportunity to have a kind of national discussion as much as possible with technology about all the different ways we can try to promote the ERA.
Jessica, I'm really glad you said that. I think I had emailed you, and I got the email from Hunter about doing it here at ASU. We just showed the movie 2 weeks ago through the 19th Amendment organization. And the movie, I think a few people may have seen it, but it is just unbelievable. It's infuriating and frustrating, and it has happy parts, and I just can't say enough about it. If you haven't seen it, you need to see it. Best to see it with a group of women. If you can get it at a university, a college, I'm going to try to do it here at ASU again. It's fantastic. Everybody should see it. Is it going to be in the movies, like, out in the theaters at some point?
No, it's not. They did a little bit of a small theatrical release, but they didn't get a distributor to get it in theaters around the country. But anyone can get the movie on either Amazon or iTunes. Right.
Yeah, we fortunately had a copy. The organization now here in Arizona got a copy, and they were allowed to show it 3 times. So we got to have one of those viewings.
Oh, great.
I highly recommend it. The other question I had, if anybody wants to jump in here, please do. But I am the president here in the state for the Federation of Democratic Women, and we're going to be having our national conference in Atlanta the second weekend in June. Has anyone talked to you about anything regarding the ERA? Like, I want to, get on a call with the board and talk about this, but I was just wondering if you've already had any contact with the president of the national or anybody else.
No.
No?
No, we haven't. I mean, not to my knowledge.
Okay.
Yeah.
Well, then I'll definitely bring it up because I'll be there at the convention. So be sure to bring it up. And Jessica, for everybody, I've invited Jessica, so you all need to come to Arizona in August. Not the best time to be here, but Jessica, is that going to work for you? I just emailed you. Are you going to be able to be our keynote speaker?
I'm hoping to do that. I mean, I think we just feel like Arizona is a really key state in a lot of ways, and it's great to have you out there. And it'd be great if you could do the screening on the 21st of April, and I'd love to come out there in August.
Great.
Despite the heat.
I got your keynote billing, so I'm counting on you. So we'll talk more about that offline. But, yeah, everyone, I mean, there's so much that we can do, I think, as an organization. And since so many of us are around the different parts of the country, we can be supportive, whether it's within our state or some of the other states that are trying to make this happen. We still have a good 15 minutes. Does anybody have any questions?
Actually, another question just came my way. And the question is, which are the states that would be the best targets for passage?
For the three-state strategy, I would say, again, Illinois, because they did actually almost ratify a couple of years ago. Virginia, because they keep getting it through the Senate, so they need it through the Assembly. North Carolina does have movement, and I think that one of the things that I would say really helped, though, in making Nevada a state where this could happen was also the focus on speaking to people who said how now they have the right makeup in their legislature, is that passage of the ERA is kind of multifaceted, and it also includes things like making sure that the state legislatures are kind of made up of members who are supportive of the Equal Rights Amendment. So it goes back also to elections. It goes back to voting. Sometimes it goes back to redistricting. Because I think one of the things that we need to look at in the states is whether, no matter what the strategy is, if this was put up for that legislature, would that legislature pass it? So not just can we pass it in the federal legislature, can we pass it in the state legislatures? So even just looking at the states like Illinois and Virginia, looking at it as not just how do we get it through those legislators, but then also how do we get it so that we have legislators in the legislature that will vote for the ERA. So it's kind of one of the things about the Equal Rights Amendment is it's kind of like a multifaceted level. So people who are working on elections are also working on the ERA by making sure that there is a legislature that will pass, the Equal Rights Amendment.
I might tell you that in North Carolina, we're using the Equal Means Equal film and trying to get it shown everywhere across the state. But then following that, some of our members are on action teams that are actually taking resolutions, taking a short, just a short PowerPoint to county commissioners, town councils, commissions on women, and those sorts of things to get local buy-in, with the hopes that we can take those things to our legislators and show that at the grassroots level there's strong support. And we've had probably 8 or 10 resolutions signed by cities, counties, municipalities across the state who have signed on to those resolutions. The plan for us is if we can't get the bills out of the Rules Committee, the bills were dropped on February 14th, and if we can't get those out of the Rules Committee at the state legislature, we plan to hold a mock hearing, a citizens hearing, and one of the legislators, our senator who introduced the bill, has agreed to help us with that. So we hope that we can put local pressure on and for people at the local level coming back to the state legislators and saying, why aren't you doing something about this?
Yeah, that's incredibly important, and I would really encourage anyone in their local districts to do the same thing because, you know, the ERA Coalition mostly focuses nationally just because that's our scope, but we have state affiliates like in North Carolina, and having that work done at the local level is equally, if not more important than what we're doing at the federal level because it's not, because once, you know, with an amendment, once it passes through the federal legislation, that's not where it ends. And so one of the things that people have said to me about, you know, from 1972 to today is some of the legislatures that passed in the 1970s they're not sure would pass today because it's gotten so conservative. So I think that in looking at passing an ERA and working for an ERA, it's also about working to make sure that the state legislatures are going to pass the ERA state and locally. So Illinois, Virginia, North Carolina, but I think not just getting it to those states and working in those states, but making sure that there is kind of a pathway to passage in those states, whether it's through local pressure, through town halls, through elections, and things like that. You know, those are all really big things that need to happen to see that success in the states.
Yeah, this is Carol. I think that's a really valid point because I know in Arizona it's been brought up the last couple of years, including this year, and it doesn't even get out of committee because this is a Republican legislature. So it's really hard to get something like that moving. But we should look at the states right now, especially, that do have Democratic legislators so that we can, you know, push this ahead. At least try.
I would just also jump in and say in Arizona, I don't know if any of you had any contact with his office, but one thing I noticed about Senator John McCain is that he was a supporter of CEDAW, which is the International Convention on Elimination of Discrimination Against Women. Right. And that's never been ratified by the Senate because they've never been able to get two-thirds vote that they needed. But he was one of the Republicans who supported it because I guess he has a kind of a human rights bent. So I don't know, since that's a women's convention, and actually it goes much further in a lot of specific ways than the ERA, I don't know if anyone has had any contact with his office, but it might be interesting to see if he would support the ERA.
Yeah, I can certainly push that forward. He seems to waver a lot. You know, he says one thing and does something else. I think most of us know that know him. But, and since, you know, EPW's been on board with CEDAW for as long as I've known. And I know we've been trying to get it passed in different states, or different cities, I should say. So, yeah, I mean, I can certainly check into that for Arizona. That's good to know.
Yeah, and I would say also making sure that, however it's positioned, or that it is a bipartisan initiative, and making sure to message it that way. Mm-hmm. We've seen that Democratic legislatures are more likely to pass it, but I think that to really make passage of the Equal Rights Amendment realistic, it really does need to be messaged in a bipartisan way. And what's exciting about Nevada, in my opinion, is that the legislatures are both Democratic, but the governor is a Republican, Governor Sandoval. And he actually came out in support of the Equal Rights Amendment and encouraged his colleagues in the Nevada legislature as well. And I think that that's really powerful because, you know, we're always so nervous that, so the opposition is going to sweep in and somehow it's not going to happen and we're going to be blindsided. But having such a prominent Republican, and yes, moderate Republican, coming out and saying, I support this, puts my mind at ease that it will likely pass. So making sure that we do look for Republicans who are going to publicly support it as well is incredibly important, because that voice of a Republican senator saying, I want my colleagues to support it, I think it gives reassurance to any Republican in the legislature that if they do, that they're not going to have, any sort of repercussion, because the most prominent Republican in the state came out in support of it. So I think that it's really important to find prominent Republicans who are willing to stand up, like John McCain, if he is. I don't know that he is, and support the Equal Rights Amendment.
No, you're absolutely right, and I don't disagree with that at all. I just find that that's where it's harder when you have
it is harder.
A state like ours.
Yeah, I agree.
Completely.
Yeah, no, I agree.
Yeah. So, but yeah, that's good, and I will contact his office tomorrow for sure.
Well, and I would just remind people that really the ERA was written by a Republican, and it had a lot of bipartisan support in the 70s. There were, 6 presidents that supported the ERA. 3 were Republican, 3 were Democrat. In the Houston conference, you had the first ladies, including Republican first ladies. So I think there's a strong history there, and I'm someone who's really worked a lot on the issue of human trafficking, and it's been an amazing bipartisan effort in Congress where you just see that members of Congress across the aisle just really think this is a fundamental human rights issue, and I think we want to position this in the same way. It's just about basic human rights and who could be against equality. I mean, that's something that really, I think, is a pretty simple statement of principle.
Yeah, we keep talking about that, Jessica, and we keep wondering who could be against equal rights, but we're finding that there are people. So that's the scary part. I'm not disagreeing with you that we've got to reach out and we've got to reach across the aisle whenever possible, but the current administration and things that are going on aren't making us feel real good.
Mm-hmm.
Yeah, no, I get that, but I think it's making a lot of people uncomfortable, to be honest with you, including a lot of Republicans. And what you see is any time there's something really questionable, which is pretty often these days, you get a bunch of Republicans that express concern. Because,
right.
If they either have the concern or they don't want to be seen as not having the concern.
Yeah.
And I think that that's something we can really work on.
I do agree with you. We've got to try harder, that's for sure. Anyone else have any questions? Last-minute questions?
Hi, this is Dean.
Yeah.
Oh. Hi. Can you hear me okay?
Yes.
Yeah.
Yep.
Okay, I have vortexes in my house that block me out every now and again. So my question is, and this will, I know, probably likely be more of a crystal ball type question, but I'm curious as to whether there's been any thought or consideration to what the plan would be should the 3-state solution be successful, and we have then an ERA with the original or close to original language. What then would that look like for the inclusion of, as you were saying, the more diverse or broader scope? Any sense of what type of impact that might have? Does that make sense?
I think it would clearly be easier to have a broader impact in the areas that we would think of as sex discrimination. So, for example, marriage equality has moved the agenda along for LGBT rights, and it's certainly possible that just using the word sex, which is in the 1972 ERA, the Supreme Court could find that includes sexual orientation. The Supreme Court could find that includes gender identity. I mean, those are all possible. And if they don't find that, let's say, gender identity right this moment in history, I think it would be really surprising if they didn't, within 10 or 20 years, change their mind, because, the Supreme Court has changed its mind on things without necessarily changing the language that it's interpreting. And you certainly see that in the LGBT context a lot. There was a very short period of time between the Supreme Court finding that, upholding the idea that sodomy could be a criminal offense, and then finding that marriage equality was a fundamental right for all Americans. So I think that that could definitely happen with some of the trans issues that people ask us about quite often. But obviously it's easier if you just put it in the language, and then there's no question about, what was intended. So I think there's a lot there. On the race discrimination side, of course, all of the issues that affect women of color are issues that affect them often in a transsectional way, and so that they're kind of interlocking discriminations. But obviously, it would be harder to cover men of color with a race issue under the old language of the ERA. But don't forget also that it is sex equality, and so it is beneficial to men as well as women. But it doesn't specifically address race in the same way that we would in an expanded ERA.
Excellent. Thank you.
Okay. Before we go, I first want to apologize. When we opened up, I didn't mention the organization, and we are the Enterprising Professional Women, part of the Business and Professional Women's Organization. That's an international organization. And I'm Carol Comito, and I'm the president of the virtual group. And that being said, I want to thank both Jessica and Bettina for being on the call with us and giving us a lot of great information to learn and work from. And we are supportive of what you're doing. We hope that we can do whatever, and if you'll stay in touch with us and share information, which I know we get through our national organization, we're all on board. I think I can speak for the group. We're definitely on board. So
thank you.
Thank you very much for your time. I don't know if either one of you want to make a closing statement before we go.
I think we just want to thank all of you for your time and for your interest and for your help. I mean, I think it's really great to be able to connect with you wherever you are all across the country, and wherever you are, there's so much that you can do to help. So I hope you'll get online and join us. And I guess I should mention our website. I don't know if you mentioned that. It's eracoalition.org. And in the advocacy section of that website, you can just put in your zip code and find out exactly where your members of Congress stand on the ERA and write to them. It's very, very easy and user-friendly.
That's good. That's good to know. Thank you. And this is recorded, so all of our members will have an opportunity to hear this whole discussion, just, if you weren't aware of that in the beginning. Okay. Anything else from anyone before we close?
Actually, there's a final question here, and this actually kind of the way to wrap it up. It says, what materials are available that we can use to educate people on the ERA?
I would say buy the book, Equal Means Equal, because it goes into a lot of case law that explains why the ERA is so important and why it's needed.
Definitely, and Jessica wrote that book. And then, and also we do have materials on our website, again, which is www.eracoalition.org. We also have a resources page, which is eracoalition.org/resources, which has information on the current bills. It has some information on international ERAs, and it has a 10 ways the ERA could have made a difference. We have action cards and brochures that if you're, a lot of times when people are putting on screenings, we send, and we could probably get you electronic versions of that as well. And also the movie is a really, really great way to educate on the need for an Equal Rights Amendment.
Okay, great. Anything else before we go? Well, thank you again so much. We really appreciate your time, and we're going to be there for you any way we can. So
thank you very much.